Please be seated, everyone. All right, back on the record. This is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Nelson and Ms. Higgs, and the people are represented by Mr. Edwards, Mr. Orman, and Ms. Pearson. The record should reflect that yesterday, at the end of the day, I had my staff email to the parties a draft of the jury instructions for phase 2 of the sentencing hearing. And we will issue a notice marking these instructions just so that there is a record of them. So this will be in the file. But what I thought we would do is move through them in the order that they appear in the draft, and then have counsel tell me if they have any thoughts or comments, and then I can take up any additional instructions. As I said, we'll only stay here till 6, but I thought it was important to have an initial sort of preliminary instructions conference today. The record should reflect that the people submitted their proposed instructions some time ago, and the defense submitted its proposed phase 2 sentencing hearing instructions on Friday. And I have reviewed both sets, and I have taken both sets into account in putting together my draft. So let's start. The first one is the one that starts with members of the jury. Phase 2 of the sentencing hearing has been completed. Do the people have any objections to this particular instruction?
Yes, Judge.
And you don't have to stand. You folks can stay seated if you want. It might be easier. It's the end of the day. And it's past 5, so I'll let you stay seated if you wish, as long as you speak into the microphone.
Okay. Your Honor, on page 4, at the top of the page it starts, if you have a cell phone or other electronic device. What I'm looking at is the 4th full paragraph. Rather, in this phase of the sentencing hearing, each of you will be called upon to make decisions based upon your individual reason, moral judgment. We would ask that the court change the language to be, you will be called upon to deliberate and to make decisions based upon your individual reason, moral judgment.
So it would read, rather, in this phase of the sentencing hearing, each of you will be called upon to deliberate and to make decisions based on your individual reason, moral judgment.
Correct.
All right. Does the defense have any objection to that?
Yes, we do. We object, Your Honor. We believe that the court discusses and addresses the issue of deliberation specifically in another instruction. There is absolutely nothing improper about the way the court has phrased this, and we ask that you keep it as is.
Mr. Edwards, what's your concern with this sentence as it appears right now?
Judge, one of the tensions in these jury instructions, the tension between the duty to deliberate and individual decision making, and they should have equal force in your instructions. It shouldn't be we have 20 instructions that talk about individual decision making and one instruction that talks about duty to deliberate.
And Your Honor, I would just add that, this instruction mentions the word deliberation several times. I'm looking at the page that we're discussing, and there is leaving other electronic devices in the jury room during your deliberations. Lastly, though you may start deliberating when I tell you, there's plenty of talk of deliberations.
But in this particular sentence, it seems to me that as it is not completely accurate. It isn't just that they're going to be called upon to make individual decisions. It's not 12 jurors who are sent back to the jury room and are asked to give us their 12 individual decisions. They're asked to deliberate, and the jury in the end comes back with a verdict that includes or that takes into account 12 individual decisions based on reason, moral judgment. But it is the jury's verdict. It's not, the verdict of each specific person. So, and Mr. Edwards is right. There is some tension about that, and that's because of the way the law is. So I will add the requested language. So it'll read, rather, in this phase of the sentencing hearing, each of you will be called upon to deliberate and to make decisions based on your individual reason, moral judgment. Any other objections from the people with respect to this particular instruction? Mr.
Yes,
Edwards?
Judge. The next paragraph, your decision in this phase of the sentencing hearing are separate and distinct from all decisions you've made previously. Well, that's not entirely correct because they consider phase one.
I thought about that. I added this because it was in the people's proposed instructions. So, and it was in the defense's proposed instructions as well. So I figured there was an agreement. I remember when I was drafting these, thinking the exact same thing that you just said. This is confusing because it's not quite accurate to say these are completely separate and distinct. I understand the point that's being made, but I think it can be confusing because, for example, they're bound by the aggravating factors they found in phase one. And so phase one and the decisions made in phase one affects the decisions in this phase. The decisions made at the end of the trial affect the decisions that the jury makes in this phase in some indirect ways. Having said that, the jury has to make decisions in this particular phase based on the instructions that I'm giving them now. And you know, I wondered about that, but both of you had it in your proposed instructions. So, Ms. Nelson, what's the defense's position?
I agree with the court. I think it should remain as is, and if the court's considering changing it, I can make a further record, but this is a separate decision, and that needs to be very clearly expressed to them. I don't think there's anything confusing about this sentence, and I would ask that it remain as the court drafted it.
I don't want to take it out completely, but I'm open to suggestions if anyone has a better idea to make this clearer.
Your Honor, the next sentence in that paragraph, which is at the top of the next page, says none of those earlier decisions dictates what your phase two sentencing verdict should be, and that is a true statement. And I would suggest that you drop the first sentence and leave the second sentence.
And Your Honor, I object to that. This is a different kind of decision-making that we see here in Phase 2. It is an individual, reasoned, moral determination that is different than the nature of the decision-making during the merits phase of the trial, and it's different than the nature of the decision-making required at Phase 1. And so they need to understand this is a new phase, it's separate, it's different, and it's distinct from all of the decisions that they have previously made in these proceedings. I think that's what that sentence conveys, is that it's distinct and it's separate and it's different, and that's accurate.
What if it said your decisions in this phase of the sentencing hearing may be affected by earlier decisions but are separate and distinct from those decisions, or something along those lines?
I think that's confusing because it suggests that the outcome of Phase 1 may somehow dictate the outcome of Phase 2. I think that's too vague and confusing, and we would object to that change.
Right, but I can also see why this is also confusing. Like I said, when I drafted the instructions, initially I saw this in the defense's instructions, and I was concerned that it was confusing. But then I saw it in the people's instructions, and I figured, well, if they're both thinking this is okay, then this must be a stock sort of instruction. But my initial reaction to this particular sentence was that it could cause confusion.
I mean, I think the other thing to keep in mind, Your Honor, is that this is just an introductory instruction. Taken as a whole, I think the instructions quite clearly articulate the role of the jury's verdicts in Phase 1.
What I might suggest, Judge, is that you rephrase it so it says, apart from your Phase 1 finding, your decision are separate and distinct from all other decisions, or something to that effect.
We object to that, Your Honor. We think that violates Mr. Holmes' constitutional rights to a fair and reliable sentencing proceeding under the state and federal constitutions.
What I'm going to do is I'm going to change the last sentence in that paragraph to read as follows. None of your earlier decisions in these proceedings dictates what your phase 2 sentencing verdict should be with respect to each count of murder in the first degree. I think that makes the point clearly, and then that makes the first sentence obsolete. So I'll delete the first sentence, but I'll change the second sentence as I've indicated over the defense's objection. What else do the people have with respect to the first instruction?
That's all, Judge.
All right, the defense, what do you have with respect to the first instruction, Ms. Nelson?
We have a couple of things on the first page of the instruction, Your Honor.
Go ahead.
In the first paragraph, it seems to me that this instruction has sort of been lifted from other, it's sort of the general instruction that the court's been giving at the end of every, at the conclusion of every step we've been through, including the merits phase as well as phase 1. And so, and my concern is with that, the section, the portion of the first sentence that reads, I'm sorry, it's the second sentence. During the course of the trial in phases 1 and 2 of the sentencing hearing, you have received all of the evidence that you may properly consider in reaching your phase 2 sentencing verdicts. You know, phase 2, as we've discussed at length, is an individual reasoned moral determination. And we continue to maintain the position that the jury can consider more than simply evidence. And so I'd incorporate by reference all the arguments that we made with respect to the language in the other instructions that we've discussed regarding the penalty phase, regarding individual reasoned moral determination having to be based on evidence. But we also object because it doesn't reference the individual moral determination. It's not just evidence, and they're making a decision based on evidence like any other phase of the trial. It's just based on facts. It's a reasoned moral judgment, and so we think that it's necessary to amend that first paragraph to reflect that concept.
Do the people have a position, a response?
Yes, Your Honor. Our response is all of the evidence is a correct interpretation of the law, and as to individual reasoned moral judgment, that is on page 3 of the instruction anyway.
I agree with the people. The reasoned moral judgment is extremely clear throughout these instructions. I mean, it is repeated throughout. This sentence doesn't say all you can consider in phase 2 is evidence and you cannot consider anything else. This is just saying that whatever evidence the jury can consider for purposes of this decision, that evidence has been introduced already and has been given to them in the trial in phases 1 and 2. And I think that's an accurate statement of the law, so the objection is overruled. In terms of whether reasoned moral judgment by a juror can just be based on nothing related to the case, I think I've made myself clear on that I disagree. Ms. Nelson is right that it can't just be based on evidence, but that's not what the instructions say. So on the one hand, it's true that it cannot be limited to just evidence because part of the decision has to include the juror's reasoned moral judgment. But the exercise of reasoned moral judgment can't be made independent of the evidence. It can't be a juror who says, well, I'm going to exercise my independent reasoned moral judgment not based on the evidence or not based on the instructions, but based on just my own, what I brought into the courtroom with me before the trial started, my own morality. On my own morality, I'm going to vote this way, and it has nothing to do with the evidence, and it has nothing to do with the instructions the court gave. It's just my own morality. I don't think that's what the state of the law is. So what's next?
Then actually the next objection sort of feeds into this first one, which is the first sentence in that bullet point of the first page. You must reach your phase 2 sentencing verdicts based only on the evidence presented in the courtroom and the instructions of law provided by the court. That, again, we contend that doesn't seem entirely accurate because it is an individual moral determination. And here it is saying you can only base your decisions on the evidence and the law. And it does seem to exclude moral judgment and mercy. And it also seems to conflict with the portion of the instruction on page 4 that states your phase 2 sentencing verdicts are not dictated by law. So we would propose just perhaps rephrasing you may consider the evidence presented during the trial when reaching your Phase 2 sentencing verdicts. However, to the extent that I tell you that you may only consider certain evidence for limited purpose, etc. I think that the purpose of this bullet point is not to explain or flesh out in great detail how the jurors go about making this individual reasoned moral decision. It seems basically aimed, this bullet point seems aimed at the limiting instructions, and so I would just propose taking out that problematic language and rephrasing it to be more targeted towards the limiting instruction that bullet point is getting at.
The reference to the instructions of law provided by the court, in my view, includes reasoned moral judgment. That's what the instructions say. So to me, the reasoned moral judgment is implied by the sentence, and again, that's made clear throughout the instructions. What's the people's position with respect to the requested change as to that sentence?
We agree with the court. It's my understanding the way the law works is this. As evidence comes in the courtroom, the individual has their moral judgment. They take the evidence, they filter it through their moral judgment, and they figure out the mitigation and the aggravation and the weight. So the reasoned moral judgment is a reasoning process. It has nothing to do with what comes into that process. What comes into that process is the evidence they've heard in the courtroom.
Okay. What's next, Ms. Nelson?
So is the court overruling my objection on that?
Yes, the objection is overruled for the reasons that I indicated.
On the fourth page of that instruction, in the same paragraph that Mr. Edwards had objected to, that last paragraph on that page that begins your decisions in this phase,
Yes.
we just maintain that the Phase 2 sentencing verdict should be based on each conviction of murder in the first degree and incorporate by reference our arguments regarding merger that were made at previous charging conferences.
Okay, and I incorporate by reference my rulings with respect to those issues. Anything else with respect to that first instruction?
No.
All right,
Thank you.
let's go to the second one. Mr. Edwards, anything from the people on the second instruction that says you are instructed that despite your findings in Phase 1, a death sentence is never mandatory or required by law? And again, I think that there was an instruction along these lines submitted by both or tendered by both parties, although not necessarily with this particular language, and although not necessarily as a separate standalone instruction. What's the people's position as to this instruction? Any objection?
Your Honor, we have no objection to that instruction.
All right, the defense?
Your Honor, we object to the word despite and ask that the court amend the wording of the instruction to read regardless of your findings in Phase 1. The word despite suggests that there's something that needs to be overcome about the Phase 1 verdicts, that somehow the Phase 1 verdicts justify death sentence, but despite all that, you can still make your own decision in Phase 2. So
I disagree, but I'm happy to change it. Do the people want to be heard on that?
No, Your Honor.
All right, I will change it to regardless, although I don't agree with the interpretation of despite by Ms. Nelson. The next instruction says you should consider all of the evidence presented throughout the proceedings related to mitigating factors. Mitigating factors include, and I think the defense had indicated that it would submit a theory of mitigation instruction. The people had submitted one that reads similar to this one. So this one is blank, and if you're not ready yet to provide that, Ms. Nelson, we can move on and we can come back to it tomorrow.
yes, Your Honor, we're not prepared
All right.
to submit that.
Okay, and the order that I put these instructions in is so that I would first tell them what sort of mitigating factors, or give the jury an example, examples of mitigating factors, or perhaps a theory of mitigation instruction, depending on what the defense submits and how I rule on that. The next instruction is sort of, or defines mitigation and provides information about how mitigation may or may not be limited, mostly how it's not limited. And then the next instruction talks about the process that the jury has to go through in deliberations. So that was the order that I put them in. I thought that made the most sense. With that explanation in mind, what's the people's position about the instruction that starts, a mitigating factor is not a justification or excuse for the crime, and then he goes from there. This is the one that defines mitigation and tells the jury how mitigation is not limited to particular things or a particular party having introduced evidence, certain evidence of mitigation.
Your Honor, in the second paragraph, the last sentence, the last phrase, it says defendant's personal history, character, background, and mental health. Well, the statute and Lockett talk about personal history, character, and background. Mental health is a mitigator that the defendant is asking for. It's the same as if when you say aggravating factor, you say the killing of more than two people or more than one person. So what you're doing by doing that, Your Honor, is putting mental health, basically telling the jury that they have to consider mental health. And mental health doesn't have to be considered. They can find it's not mitigation, and therefore should be in the defendant's theory of mitigation instruction, but should not be in that phrase.
All right, Ms. Nelson?
Your Honor, I don't even understand the argument. Mental health is very obviously a part of a person's personal history, character, and background. It's a huge issue in this case. There's no question about it. It is mitigating, and they are not free to disregard it as a mitigating factor if they find that it exists. It's perfectly appropriate to be in that instruction. And again, this is not a goose gander type situation. There is specific Eighth Amendment jurisprudence that has been clearly established by the United States Supreme Court that the jury has to fully be able to understand, appreciate, consider, and give effect to all relevant mitigating evidence that's presented by the defense. And so I would ask that remain in the instruction.
Yeah, I don't read the instruction the same way that Mr. Edwards does, and I know that he has a lot of experience in this area, but the jury doesn't have that experience, and that they're not going to infer from it what I think he is inferring from it. This just simply is giving a broad overview of mitigation, the concept of mitigation, what it can include. This is not going to be any news for the jury. This is not the court saying, hey, any evidence of mental health, you have to find that that's mitigation. This is just saying mitigation could include mental health. It is up to them to determine whether that amounts to mitigation or not. So the objection there is overruled. What else do you have, Mr. Edwards?
Your Honor, in the next paragraph, it says this is third sentence, a jury may find a mitigating factor, circumstance, and evidence, even if it has not been specifically called to his or her attention by the parties. Another tension in these jury instructions is between reliability and arbitrariness. The defense has to be able to say, this is mitigation. And all the case law that's been decided in argument on the other instructions in the introduction to Phase 2, it's got to be a reliable process. And when you say, jurors, you can find whatever you want to, and you don't even have to articulate it, you're putting arbitrariness into the process. It's a reliable process. It's just not reliable as to the prosecution, but arbitrary as to the defense. It's not arbitrary as to mitigation. They have to delineate it in their theory of mitigation instruction. In the Owens case, the public defenders put in 65 specific mitigators. In the Ray case, they put in 84 specific mitigators. So they have a theory of mitigation, and that's it. There is no law that I am aware of, and I'd love to have the defense cite it, that says the jurors can arbitrarily decide something is mitigation that has not been instructed on, has not been argued by the defense.
Ms. Nelson?
I'm completely befuddled by Mr. Edwards' argument, quite frankly, Your Honor. The issue of arbitrariness within the Supreme Court's Eighth Amendment jurisprudence all has to do with aggravation and with proper narrowing of eligibility of capital defendants for the death penalty. It has nothing to do with mitigation, and in fact, quite to the contrary, there is myriad support in the case law for this issue, for this concept, that a juror has to be able to consider and give effect to any reason that could be a basis for a sentence less than death, I would cite the court to Lockett versus Ohio, Eddings versus Oklahoma, Mills versus Maryland, McCoy versus North Carolina, Tenard versus Dretke, Henry versus Linnell, just to name a few. There is absolutely no requirement that the defense has to offer this as a mitigating factor to the jury. I think the court's video instructions had similar language to this. I think we discussed this during or litigated this issue when we were going over the court's video instructions. We also discussed this with the prospective jurors at length during voir dire, this exact concept. This is totally consistent with what these jurors have been told all along, and anything that suggests that it has to be presented by the defense in order for the juror to find it to be a mitigating factor unconstitutionally limits mitigation, and I would say to Mr. Holmes's constitutional rights under the state and federal constitutions to due process, a fair and impartial jury, and a fair and reliable sentencing proceeding. Fifth, Sixth, Eighth, 14th Amendments, and Colorado Constitution, Article 2, Sections 16, 20, 23, and 25.
All right. Do you have any cases that specifically talk about this issue that say that it doesn't have to be something presented by the defense as mitigation, that the jurors can on their own figure out that it's mitigation even though the defense did not present it as mitigation?
Well, frankly, I think Lockett supports that position. In Lockett, the United States Supreme Court was dealing with an Ohio statute that specifically listed several mitigators. And the United States Supreme Court found that that was unconstitutional because it restricted a juror's consideration of any relevant mitigation at all. So I would cite to Lockett, but I also I cite to all of the cases, and I stand by the record that I made previously. All of these cases talk about how a juror's consideration of mitigation can't be limited. And in addition, I would cite to the statute, the Colorado's capital statute, which says that jurors, all of the relevant evidence that was presented at the merits phase of the trial can be considered by the jury at sentencing, subject to the limitations that we're well aware of and that we've discussed. So I don't see any support in the law for notably Mr. Edwards hasn't cited a case in support of his position either. I think I have cited case law that supports my position, but I just have no idea where this concept is coming from, frankly.
All right, I'll take that under advisement. Mr. Edwards, do you have any case law that you want to cite?
No, Your Honor, but if you look at Lockett itself, Lockett talks about relevant mitigation. Well, who decides what is relevant? It's not the jury that decides what's relevant, it's the court that decides what's relevant. So relevancy determination is up to the court. So those cases that have been cited by the defense do not support their position. If they can come up with one case that they can show the court that the jury can arbitrarily decide what is mitigation if it's not argued, I will withdraw my objection. But there is no case out there that says that, Your Honor. Not one case says the jury can arbitrarily decide. What those mitigation cases talk about is all kinds of mitigation that is presented by the defense, is filtered through the judge's relevancy determination, and argued to the jury.
Okay.
And Your Honor, if I can just cite the court to a specific quote from McCoy versus North Carolina.
What's the citation?
494 U.S. 433 440, 1990.
494 U.S.
433 440.
Okay.
A state cannot prevent the consideration of evidence if the sentence could reasonably find that it warrants a sentence less than death. If the sentencer could reasonably find that it warrants a sentence less than death. That means that the sentencer can reasonably find that it warrants a sentence of less than death. And this is consistent with this whole line of cases from the U.S. Supreme Court. Every time this issue comes up, no matter which context it comes up in a statute, it comes up in Eddings versus Oklahoma, where the court refused to consider something that was presented as mitigating or found that it wasn't mitigating. Then it comes up in McCoy and in Mills, where it's this requirement that the jurors unanimously find mitigation before they can consider it. Anytime this issue comes up, and regardless of the context, the U.S. Supreme Court always holds that you cannot put limitations on a juror's consideration of mitigating evidence.
Okay, what's next, Mr.
Judge,
Edwards?
can I respond to McCoy?
Yes.
Because in McCoy, they talked about specific mitigation. They talked about impaired ability to appreciate criminality of conduct because of his mental condition, borderline intellectual functioning, under the influence of mental or emotional disturbance, age, several decades exhibited signs of mental or emotional disturbance or defect, ability to remember events of the day of murder was impaired. All those were put on by the defense. The court wouldn't let the jury consider that. Well, it was put on by the defense, it was argued by the defense, and the jurors were deprived of the ability to consider all that evidence. And so again, it's the attorney presenting it, filtered through the judge who finds that it's relevant, and argued to the jury.
Wait, I don't have McCoy in front of me. You're saying that all that evidence was presented, but the jury was prevented from considering it. How was the jury prevented from considering it?
I don't have the case in front of me, I just have my note. And that is all the evidence that McCoy versus North Carolina talked about as mitigation.
Right, but you're saying it was introduced into evidence, right?
Yeah, it was introduced into evidence.
So
The
how
jury-
was, right, how was the jury not allowed to consider it?
Well, the same way as in the Texas cases. And what happened in the Texas cases is there were 3 jury instructions that were given under Texas law. And this is as Texas law developed. And what the Texas courts ended up doing was saying, defense, you can present the evidence, but in answering those 3 questions, there was no way for the jury to consider mitigation. So the judges, the trial courts, were permitting the defense to put on whatever mitigation they wanted to. But in answering those 3 questions, they just didn't mesh. Mitigation was not a consideration in those 3 questions.
Your Honor, may I add something? Because it occurred to me that this is another very big problem in this case, which is that this is an insanity case, and we had 2 months of a merits trial in this case, and a lot of the mental health evidence, quite frankly, came from the prosecution. I mean, they put experts on the stand who diagnosed Mr. Holmes with a very serious mental illness, and we may be relying on that. We may not touch upon all of that in our closing, but the point is, I mean, it certainly would be absurd for jurors to believe that they couldn't consider the testimony of Dr. Reed that this was a serious mental illness, that it was the but-for cause of the shooting, or that they couldn't consider Dr. Metzner's testimony in the merits phase as mitigation because we didn't put it on, because they put on those witnesses. It just makes no sense in this case. And the problem is, you know, we're relying on all of this evidence that came before. And a lot of it was presented by the prosecution, but that doesn't mean that the jury can't find it mitigating if it touches upon Mr. Holmes' mental health. And the court's given us 40 minutes for a closing argument in phase 2. We might not hit upon every single thing that was mitigating about the merits phase of the trial.
Well, but I don't know if that's a good example, because you're going to include mental illness, obviously, mental health, obviously, as one of your mitigators. So it's not like a juror is going to think, mental health should have been a mitigator. It wasn't mentioned by defense counsel, but I'm going to consider it a mitigator. That's not going to happen, because obviously mental health is at the center of this case. So let's move on. I'll read Lockett and the other cases cited, McCoy and the other case cited by Ms. Nelson, and then we'll go from there. What's next on behalf of the people with respect to this instruction?
Your Honor, the same principle applies to the entirety of that paragraph. And so I'm not going to specifically argue it any more than we already have. The last paragraph that starts, the court instructs on the next page, I'm not sure that you need aggravation or as an aggravating factor. It should just not be considered as an aggravating factor, because that's all the jury's been exposed to, is aggravating factors. They don't know this difference between you have statutory aggravating factors and you have these other aggravators and you have aggravating circumstance. At this point, they haven't been advised of the distinction. I don't know if they ever will be in this case. But I think it should just be as an aggravating factor.
Instead of aggravation? Is that what I'm not sure.
Well, you take out as aggravation, you still have as an aggravating factor.
Oh, I see. right, the court instructs you that you may not in any fashion consider any mitigating factor as an aggravating factor is what you're requesting. All right, any objection, Ms. Nelson? Yes.
We object, Your Honor. We think that you need both to make it clear to the jury, because otherwise, I mean, I certainly think it's possible that they'll think, okay, well, you know, we've already found the aggravating factors, but I can consider this as, you know, aggravating in some other sense. So I don't think it hurts at all to keep it in, and we're requesting that the court keep it in.
All right, I disagree. I'm going to take it out. The request is granted. The point is made without those words, and it's actually better without it. It avoids any confusion. So there's no reason to say two different things if I'm saying the same thing, and that's all I intended to say was the aggravating factor. So, all right, anything else from the people with respect to this particular instruction?
No, Your Honor.
All right, Ms. Nelson, do you have anything other than, I obviously understand there's a disagreement with respect to that third paragraph, but anything else with respect to this instruction?
A few things, Your Honor. In the first paragraph, we would ask that the court include, this is from our proposed instruction 71, that second sentence, rather a mitigating factor is a fact or circumstance which in fairness or mercy may be considered as extenuating or reducing the degree of the defendant's moral culpability or diminishing the appropriateness of a death sentence. We would again cite the court to the cases that I relied upon previously, as well as Tenard versus Dratke in particular.
Do the people have a response?
If I might have a moment, Judge. Do you have anything to say right now? Okay, I don't have any objection on that, Judge.
Yeah, I think that's an appropriate change. So I will add that language. It'll make the sentence a little longer than I would like, but I'll just add or, I'll put a comma after culpability, and then it'll say or as diminishing the appropriateness of a death sentence. What else?
Then on the second page of that instruction, well, it's actually the sentence that bleeds over from the first page to the second page. Therefore, any list of mitigating factors mentioned in these instructions cannot and does not limit your deliberations. This is the phase where we're talking about each individual juror having to find for himself or herself the existence of mitigation, and so it just didn't read right to me to say it cannot limit your deliberations, and we would propose cannot and does not limit your individual determination about mitigation instead of the word deliberations.
Without waiving your general objection to this paragraph, do the people have a position on that request?
Yes, Judge. What we would ask that it says does not limit your deliberations or your individual moral judgment.
Or your individual reasoned moral judgment?
Yes.
But I think it has to say your individual determination about mitigation, because that's what we're really talking about, is their findings regarding what's mitigating and what isn't.
What the defense is asking for is anti-deliberation.
I don't understand that. No. We're asking them to find, I mean, that's the whole point of phase 2, is that they individually find mitigation. Each juror finds for himself or herself the existence of mitigation.
Okay, I'll think about that one. Okay, the next instruction is the one that starts with, when you retire to deliberate on your phase 2 sentencing verdicts, each juror must first independently determine with respect to each count whether one or more mitigating factors exist. Do the people have any objections to this instruction?
Yes, Your Honor, we object to that first sentence because it's anti-deliberation, because it says each juror must first independently determine, which suggests to the jury that they have to go out and each stand in a corner and decide for themselves what mitigation is without deliberating.
All right, Ms. Nelson?
The instruction, that sentence has the word deliberate in it. I don't see how that can be considered anti-deliberation. I understand the prosecution may not like the fact that what is required of jurors at phase 2 is to make individual decisions about mitigation, but that's what the law requires. It's an individual reason moral decision. There's plenty of language in here about deliberating. I just don't, I fail to see how that's an anti-deliberation language. It just doesn't make any sense to me. Each juror does have to independently determine with respect to each count, or in our position, each conviction, whether one or more mitigating factors exist. That's exactly what the law requires a jury to do. And that's totally consistent with what the court has been instructing the jury all along. And in fact, I think this language is pretty consistent with what the court instructed the jury on in the introductory instructions to phase 2. And I'm concerned if we're going to be changing the law on the jury now in these final instructions. I don't remember the prosecution making any similar objections to the court's introductory instructions to phase 2. And if my memory, I don't have them in front of me, but if my memory serves me correctly, it's pretty similar.
And I think counsel for both sides used similar language in individual voir dire as well. I don't remember anyone taking the position that the jurors don't have to individually determine whether any mitigation exists as an initial matter.
Judge, that's not our point. Our point is that the sentence says each juror must first independently determine.
So they independently?
First. No, I'm not arguing that. First is the problem. First is the problem. Because if you say first, what you have to do is go out and independently decide.
Okay.
So if you take out, maybe if you took out first, each juror must independently determine. If you took out first,
all right.
then
Does
I'd
the
have no
defense have
objection.
any objection to first coming up? I don't know that it's that big of a deal. As a matter of logic, that's sort of the first thing jurors are going to have to do. I mean, you can't assign any weight to a mitigating factor unless you first have found that there is a mitigating factor. And
No.
you can't do the weighing process unless you have first found that there are mitigating factors to weigh against the aggravating factor.
Then
So
put first before when at the beginning of the sentence.
first, when you retire to deliberate?
Yeah.
Okay. Is that okay with you, Ms. Nelson?
No, we object. We think it should remain where it is. It doesn't read correctly if you put it in the beginning of the sentence.
Given what the rest of the instruction reads, I'm going to take out first because it's clear later on that has to happen first. And I don't think I need to be telling the jurors what is the first thing they have to do in deliberation. So I'll take out the word first. For the record, the next paragraph starts with, once a juror has determined that a mitigating factor exists, and it goes from there. And it's clear what the process throughout is. So I don't like it at the beginning of the sentence either. I agree with Ms. Nelson. It doesn't read right, but I also don't think it's ideal to have it in there. So what else do the people have with respect to this instruction, Mr. Edwards?
The next page, first paragraph, it currently reads, each juror must individually decide. We would ask that it read, each juror must, after deliberation, but individually decide.
All right, Ms. Nelson.
I don't understand that. That's not the law. So we object.
And I'm telling them throughout that they have to deliberate, so I don't think that's necessary. All right, so the request is denied. What's next, Mr. Edwards?
Your Honor, if I can just interrupt briefly, the court said you would go till 6, and I have an appointment. I'm just trying to figure out where I should, whether I should delay it, how late the court really actually intends on going.
We'll stop here in a couple of minutes. You're free to go if you want, but we'll stop in a couple of minutes. Mr. Edwards, do you have anything else with respect to this particular instruction?
No, Your Honor.
All right, does the defense have anything with respect to this instruction?
A few small things, Your Honor. On the first page, last sentence, but the juror may not give a mitigating factor we think it should say he or she has determined exists.
No objection.
Okay, that's a good change. What else?
And then we would ask the court on the next page of that instruction, in the first sentence, each juror must individually decide what weight to give to each mitigating factor he or she has determined exists with respect to a count. We would ask the court to remove with respect to a count. And I understand that the court is trying to convey to the jury that they have to engage in this weighing process for each individual count. And again, we maintain our objection to that and that it really should apply to each individual conviction. But setting that aside, I think that's adequately conveyed in the instructions. I think the court says with respect to each count enough. And it's just, I don't know, it just struck me as odd to include it there. I mean, in the beginning of the very next paragraph, the court says with respect to each count, each juror must weigh the mitigating factors that he or she has determined exist against the aggravating factors. So,
any objection, Mr. Edwards?
No, Your Honor.
All right, I agree with that proposal. What else?
We would object to the court sending back copies of the Phase 1 verdict forms with the jury. That just, we don't think it's necessary. The jury just found aggravation, and if they have any questions about what their own findings were, I suppose they can inquire, but we don't object to that.
I think I have to do one of two things. Either I send back the verdict forms with the jury, or I tell them specifically, remind them specifically what the aggravating factors were that they found in these instructions. So, what's your preference? Yes.
To be that the court just instructs them on the aggravators that they did find.
Okay, do the people have any objection to that?
Yes, we do. We would ask the court to send back the verdicts so that the jury is very clear about each count and what aggravating factor they found.
Well, they found the same 4 aggravating factors with respect to all the counts, so I'm just going to list them here.
And the concern, Your Honor, is that that if the verdict forms are sent back, they're also reminded about the aggravator that they didn't find.
Right. Okay.
Improper.
I agree with that argument. Anything else, Ms. Nelson?
The last thing on this instruction is just that very last sentence of the instruction, and I would just incorporate by reference the arguments that we've previously made. The exercise of your reasoned moral judgment must be based upon the evidence presented during the proceedings. And this again goes back to the concerns that we raised previously, tying the jurors, limiting the jurors' exercise of moral judgment to the evidence.
Okay. I'll incorporate by reference the rulings I have made with respect to that issue, or the comments I have made, and the ruling I have made with respect to that issue. And I'm assuming that people stand by their comments as well.
Yes, Your Honor.
All right. It's 10 after 6, and so let's go ahead and stop for now. Before we leave, do you want to give me each side? Is there a big issue that you see in the rest of the instructions? Not small stuff, but if you give me a heads up about any global issues or any particular concern that you have, then I will know that it's something that I need to look into. Do you have anything, Mr. Edwards?
If I can just list some of them. Not the next instruction, the instruction after that talks about you must not be influenced by prejudice.
Oh, you know what? That's missing some I think that might be missing some language. Let me check that. That might be a typo, okay?
And one of the last instructions says there is no requirement that you articulate, explain, justify to your fellow jurors why you reached a particular determination. And it's our position that that's arbitrary. If you can't articulate it, and it plays off that it's got to be presented to the jury. It's got to be in a theory of mitigation instruction. Perhaps also in an instruction or in their argument, but
Which is that the instruction that starts with, there's no requirement that you articulate, explain, or justify to your fellow jurors why you reach a particular determination?
but
Okay, you're objecting to that paragraph?
yeah, so we don't know if they allow this.
I think that people may have included language along those lines in their tendered instructions, so.
And Your Honor, if I can just add, I know that we talked extensively to the jurors about this during voir dire. And just noting for the record, Mr. Edwards wasn't present for any of that, but I don't recall any objection from the prosecution. And the same goes for this concept, and I know, I have a vivid image of Ms. Spengler in my mind telling jurors that they can put on their mitigation caps and go looking for mitigation. Same issue here with the whole concept of whether or not jurors can use their own use their own sense of judgment to find mitigation. It doesn't have to be something that is pointed out to the jurors by the parties or argued by the defense. I know we discussed this with individual jurors during voir dire without objection. So.
All right, Ms. Nelson.
If that was wrong, Judge, if that was done and that is wrong, what the court needs to do is advise the jurors today on what the law is.
I understand. That's why we're having this discussion. I'm not going to misadvise them if it's not supported by the law just because somebody may have said something about it in voir dire without objection. But I understand the point Ms. Nelson is making. All right, Ms. Nelson, do you have any? Yeah.
I've got a very short one-sentence instruction.
Can you show it? You
I
can.
gave a
Great.
copy to the defense at noon.
Yes, thank you. And for the record, this reads as follows. While you may consider compassion for the defendant based upon the evidence, any compassion for any other person, including the defendant's family, friends, and other people, is not mitigation and should be excluded from your consideration. All right, Ms. Nelson, do you have anything major or global that you might want to make me aware of before we adjourn for the day? You're not obviously limited to what you're going to say now. I'm just asking if there's anything that I should have a heads up on before tomorrow.
Your Honor, I perceive most of my objections as fairly quick. The one thing I did want to call the court's attention to, because it's sort of a change in position for us after reflecting upon it a little bit more last night, is that the instruction on reasonable doubt, the freestanding instruction on reasonable doubt,
Yes.
We were just reading over the language of this instruction last night, and we kind of came to the conclusion that it doesn't really make a whole lot of sense in the context of a Phase 2 sentencing decision, because it talks about a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence, the lack of evidence in the proceedings, when really what we're talking about here is a degree of moral certainty that each individual juror has to have. And that's mentioned in the previous instruction, the instruction just before that instruction, where the court says, in Phase 2, the use of the term beyond a reasonable doubt does not refer to a party's burden of proof. It refers to the level of moral certainty that each individual juror is required to have before he or she may conclude that the mitigating factors that exist do not outweigh the aggravating factors, etc. And so our request would be that that's how we define reasonable doubt for them in Phase 2, and that we don't include this stock instruction that's really drafted for a regular non-capital merits phase of a trial.
Mr. Edwards, do the people have a position on that?
Yes, Your Honor, I totally object. The statute says that these decisions have to be made beyond a reasonable doubt. The Colorado Supreme Court has said beyond a reasonable doubt. They have not defined it as the defense has defined it. They've defined it as it is in the jury instruction.
Okay.
Pattern jury.
All right, I'll think about it. Okay. All right, folks, thank you very much for staying so late. I appreciate that. I'll see you tomorrow morning at the usual time. The court will be in recess. Thank you.